In 1948, Supreme Court Justice William O. Douglas wrote, "The Federal Employers' Liability Act was designed to put on the railroad industry some of the costs of the legs, arms, eyes, and lives which it consumed in its operation. Not all these costs were imposed, for the act did not make the employer an insurer. The liability which it imposed was the liability for negligence." In the late 19th and early 20th centuries, the railroads changed the nation. From 1889 to 1920, railroads and their use grew exponentially. It was a golden age, with railroads and their generals conquering a vast and wild American continent with the reality of power. Power over time and power over distance. Massive locomotives, 50 or more tons of steel, pulling heavy loads of freight. Steel wheels on car after car rolling heavily over steel rails. Conditions that could kill or dismember a person in an instant. In 1906, Congressman Henry Flood of Virginia exposed the high rates of injury and death of rail workers as he called for legislation to protect rail workers and their families.
In 1907, the statistics show that there were over 83,000 injuries. There were 4,500 deaths to railroad workers, and there were over 3,000 train accidents in that year. And the life expectancy of an operating employee at that time, from the date that the employee started work, was only 7 years. Couple the horrendous statistical data plus the outrageous conduct of the carrier, Congress saw fit to take care of the problem.
The result was FELA, the Federal Employers' Liability Act of 1908, a visionary piece of legislation passed by Congress to prevent the injured railroad worker from being crushed by the giant legal machine of the corporate railroad industry. Today, FELA is just as important to rail workers as it was 100 years ago. The truth is, the hazardous elements of railroading have changed very little since 1908. They've just become bigger, heavier, and faster. Railroading is still a highly hazardous occupation. When something goes wrong, people are injured, people die. That's a truth that has remained unchanged. Even now, 100 years later, every year 1 out of every 10 railroad workers is injured on the job. 1 in 10 every year. What is it about FELA that makes it so important? In spite of attempts to replace the FELA with some system of workers' compensation, Congress has wisely refused to alter the act.
When they compare it with the workmen's compensation laws, they see very clearly that workmen's compensation is totally inadequate in providing for reasonable recovery for someone who is injured and the loss to the employee. Secondly, workmen's compensation is more litigious than the FELA. Over 50% of the workmen's compensation claims are handled to a trial, not resolved, as compared with only 2% of the FELA cases go to a trial.
While the railroads and others have repeatedly attempted to gain repeal of the statute, Congress has steadfastly rejected these efforts, insisting that FELA, in the words of the GAO, remains an effective law and continues to work as it was intended.
The importance of the FELA was illustrated when Rick Hubner and Harry Pearson were injured in a train wreck in Arizona.
I was on the second unit of the train. I was brakeman. Rick was the conductor. And we come over this hill and there was a train in emergency. And they notified us that the train was in emergency, but it was too late for us to do anything. And we run into the side of the train and it caught on fire. The fire was burning all around us and Rick and the engineer was trapped in the front unit.
We just went in there and plowed right into them. You know, there was fire, there was noise that just, I can't even describe the noise. It was something I'd never want to, you know, experience again as long as I live.
This one Rick was on here. Rick had to push that door open with his shoulder, and that's when he hurt his shoulder and knee was in here. That's the unit I was on, right there. When it hit, it just everything caught on fire. And I shut this window and the fire went back out that window, or the other window, and I come out this door and jumped off on the ground. The train was still moving, I jumped off. It's just the way they treated us, you know. They fired us right there. You know, wasn't even our fault, and they fired us, the whole crew. I didn't want to sue nobody, you know. I just wanted my job back. But my back was really started hurting me bad, and then I knew I had to do something, you know, because I wasn't going to be able to go back to work. It was a tough time there, really tough time trying to make a living. It's terrible, and if we didn't have these kind of laws and the union to fight for us, we'd just be out of luck, you know. I'd been out on the street somewhere.
Through the years, opponents of FELA have circulated misconceptions about it. One such myth is that the law is too old and it should be replaced with a more modern system, workers' compensation. In reality, workers' comp is virtually just as old, having begun just 3 years after FELA. Another myth is that FELA cases require hiring a lawyer, while workers' comp doesn't. The reality is that 3 of every 4 FELA claimants resolve their case without an attorney, while in many states, workers' comp claimants hire attorneys 50% of the time. Perhaps the worst myth is that under FELA, many injured rail workers end up with nothing. In reality, virtually all FELA claimants, more than 99%, receive compensation. Under FELA, an injured worker is entitled to compensation for present medical expenses and for future medical expenses related to the injury, for current loss of wages and for future loss of wages, as well as compensation for present pain and suffering and for future pain and suffering. This has resulted in perhaps the single most significant achievement of FELA, safer railroads.
The FELA is first and foremost a safety statute because it has shown for over 100 years that it is an incentive to the rail industry to improve safety. In congressional testimony by the chairman of the board of the Norfolk Southern Railroad before Congress, he stated as follows.
The FELA has a tremendous effect on our corporation, as it does on all other railroad corporations. This was one of the things that drove us to our current safety program of bringing the workers at the very bottom level into the program, along with the top management. Our activity there led us to a formal quality program because of the success we have had in reducing accidents, reducing injuries, and consequently reducing potential for FELA claims.
I think this says it all. FELA is the effective law that will help prevent accidents and injuries.
As we start talking about global warming and the expansion of railroad activities across America, we're also going to be talking about the expansion of opportunity for more accidents. Even with our best efforts and the best efforts of the railroads, people will get injured. We have to make certain that there's fair compensation for their injury.
Now is not the time to accept any weakening of rail safety, which would be the inevitable consequence of weakening FELA. I promise to you that I will continue to hold the line on FELA.
Today, FELA remains as relevant as ever. As Supreme Court Justice Ruth Bader Ginsburg said, the cost of human injury, an inescapable expense of railroading, must be borne by someone, and the FELA seeks to adjust that expense equitably between the worker and the carrier. FELA, fair, efficient, and a law that promotes safety. That is FELA at 100, a time-tested landmark law that still works as Congress intended.